This is a termination of tenancy action. The parties live in the same house, and Mr. Rohr wants Katie Rohr to move. Mr. Dutka, anything else to add?
No, Your Honor. Actually, my client has vacated the house. He just wants to get it returned to him. So that's the only thing I can add.
All right, Ms. Rohr and Ms. Bell,
Yeah.
you are a tenant in a landlord-tenant proceeding. In both cases, the landlord is asking to terminate the tenancy. In such a case, you have a right to hire a lawyer. If you can't afford a lawyer, you can see if legal aid would be willing to represent you. For many weeks, we've had a legal aid representative here on the live feed. We've lost that the last few weeks. We do have a legal aid representative here today, but you can seek representation from legal aid or other possible source. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance, or be prepared to file a written demand within 5 days. And either way, you have to file a $50 jury demand fee unless the judge waives the fee for your inability to pay it. You may be able to reach a resolution with the landlord by going through mediation. If both parties are interested in doing a mediation, the court can help set it up. And finally, you may be able to reach an agreement with the landlord, which would result in a mutual resolution of the matter, in which case Mr. Dutka would file what's called a conditional order of dismissal, or perhaps Riverside could. All right, Ms. Rohr, what's your position? Hugh says he owns the house, he's out, he wants you to move.
Yes. I'm looking for a place. My dad, he moved out of the house, and then I moved into the house, but he wants the house back, and I understand that. And I found a place, and then he keeps changing his mind, but now he's, I guess, serious. And I'm trying to find something. I am not having any luck. If I had something, I would move out. I would have already been gone. I'm looking.
Well, that's a common refrain we hear every week. People would move if they had somewhere to move to. But this is the process where the judge forces the issue. You do have a right to have one 7-day adjournment. Next Monday is Memorial Day, so we won't be here that day. So we'll look to Friday the 29th. Mr. Dutka, are you available on Friday morning, the 29th of May?
I can be, Your Honor.
Oh, boy. How about 11:10 Friday morning, May 29th?
That works for me, Your Honor.
Ms. Rohr, if your landlord gets what they're asking for, you would have 10 days from May 29th to vacate, which would be June the 8th.
Yeah.
June the 9th.
Okay.
No, June 8th. So at that point, if you didn't vacate, the plaintiff could ask for a writ of eviction and the sheriff could come forcibly put your stuff out. That happens a couple dozen times a year when people just don't go and the sheriff has to forcibly evict them. But this is a situation where it's family, there is no lease, you're not paying any rent. He wants you to vacate so he can move back in. I encourage you to continue to look for another place to move to. We'll revisit this May 29th at 11:10.
So I do log back in and call this number again, May 29th at 11:10?
Yes, I don't want to do it by telephone. I want you to either do it by Zoom or come
Okay,
in
I'll go
live
to
to
the
the
library.
courthouse. All right,
Okay,
I can't
okay,
see
sounds
you. I don't know who I'm actually speaking to.
okay,
So at any rate, you should plan to be ready to vacate by the 8th of June, or you'll be subject to being evicted.
right.
All right. Do you have any questions?
No,
All right, I'll see you on Friday, 29th of June at 11:10.
all right, thank you.
All right, thank you.
Thank you, Your Honor.
Thank you, Mr. Duck. I'll see you next time.
Yep.
Ms. Bell is here with her emotional support dog. Uh, Mr. Adam Freeman is here from Legal Aid on behalf of the defendant. Lori Kalmbach, the manager at Riverside, is present, and James Gromer is here on behalf of Riverside Townhouses. This is filed as a termination of tenancy case. The landlord wants the defendant to move, and it has to do with dogs, more than one dog, and perhaps other issues. Mr. Gromer, what's the plaintiff's position here?
Your Honor, I think you have aptly described the plaintiff's position. I would like, if I didn't say so, James Cromer, P63503 on behalf of Riverside. I did receive some correspondence, I believe, from Mr. Freeman's assistant. We did correspond some emails back and forth, and I did just receive an answer. So I think it would be appropriate, unless Mr. Freeman agrees, Your Honor, is to set this for a second date. And then hopefully Mr. Freeman and I would be able to have more conversations.
That is appropriate. We just discussed the fact that next week is Memorial Day, so that would take us to the 19th, excuse me, the 29th. That morning's quite packed, but
Your
how
Honor,
about 10:30? Yes, Ms. Kalmbach?
like I said last week, I will not be here on the 29th. I'm off all next week.
I think we'll be able to, are you willing to do it without the assistance of your manager?
I actually believe that this is statutory as it relates to the 504, so I don't think it's necessary.
Yes.
My only caveat to that was if Mr. Freeman, obviously the documents that I've already provided to him that he's seen, that he wouldn't object to the admission of those. They're the same documents he's had, or he'd let me know ahead of time.
All right, well, let's go for 10:30 on Friday, May 29th. Ms. Bell, does that work for you?
I don't know. I don't have my calendar.
Well, you can come in by Zoom. Now, as a rule, we don't let dogs in the courthouse.
It's about this dog, and he helps take care of me.
All right.
And the thing is, though, they
All
want
right,
to let me out.
just a minute.
I'll take that.
All right,
She had any tears when I told her.
all right, all right. The allegation is you have more than one dog.
I have his mother, and he was
All right,
born there.
so
But the thing is, there's other people that's got 3 Great Danes in
All
there.
right,
They
well-
got more than 10 cats. They're picking on me, and I don't like it.
I don't know anything about that.
Well,
Now-
you will know
All
about it
right,
when I'm
now,
done.
when you come here again, you can't bring your dog.
Then I guess I don't come to court then, do I?
Well, you can come in
Because
by,
this one comes
you
wherever I go.
you can come in by Zoom.
I don't have
and-
my phone.
You can
And like I said, I told them.
have as many dogs as you want. They just don't want you to have them there. So we're gonna revisit this next 10 days from today. Actually, 11 days from today, Friday, May 29th at 10:30, live here at the courthouse. Now, you've got competent counsel from Legal Aid. They're as good as anybody at landlord-tenant cases. This law firm that's representing the complex also does a lot of landlord-tenant law. There's some specific statutes that apply when you're at apartment complexes that are federally subsidized. The rules are stricter. But there are also rules regarding emotional support animals. I don't know who's got a dog at Riverside. I can't
I'm
imagine.
gonna start
someone-
naming them off.
Well, not, we don't need it at this.
3/4 of the place does,
Um,
and then more cats too.
okay, I don't know the answer to that. All I know is I got this case for you. Now, who did you bring with you today?
Tigger.
And
His name is Tigger
who's your
Todd.
support person?
I'm in the area agency and aging on elderly victim specialist.
All right, you've been here before, I think, haven't you?
Yes, usually it's Tony, but she.
And what's your first name? All right, so they want you to move. You don't want to move. You want 2 dogs. They want 1 dog.
Then tell them to give up a child then.
All right, well, none of this was my idea.
No, I'm talking to her. She knows it. I had nothing to do with that woman anymore.
All right.
And she'll know it when I get done with her. Because this is not the first
Now,
one. I'm taking her for
Ms. Bell, we're gonna rediscuss this next Friday. In the meantime, the lawyers are gonna talk to each other. The very worst case scenario for you would be you'd have to move 10 days after May 29th, which would be June 8th. That's probably not gonna happen because we may need further hearing on this matter. But the law requires that I adjourn the matter at least 7 days. So I read the pleadings, I read the answer.
But it's all right for everybody else to have more than 1 dog, right?
Well, I don't know,
More than
and I
10
don't
cats
know,
in their apartments and a hoarder.
well,
Hey, Lori.
I've seen those cases, but this has to just do with yours.
Yeah, she's been tormenting me ever since I've been there with other leases. For 4 years, I've been nothing but harassed in that apartment.
All right, well, would you like to move?
All I know is this harassment's gonna stop, and I'm not giving up my children.
All right, well, I said you can have 100 dogs if you want, if you go a place that allows it.
There's
So,
aggressive dogs in there, there's pit bulls in there, and she's allowing that. My dogs are not aggressive, they're not pit bulls, they're service animals.
all right, well, there's a requirement that you have to actually meet for it to be a service animal. People put a leash on a dog and a vest and they call it a service animal. There's more to it than that.
I know that, I've had one for 18 years.
Well, I think the other one is, and I think this one isn't, which is what.
He is in the process of being trained to be a service dog. For crying out loud, you gotta give him training to be trained.
Your
It
Honor.
doesn't take overnight.
All right, yes,
Your Honor. Yeah, she did I was gonna see opposing counsel. She did submit new request from a psychiatric nurse practitioner for a 2nd dog with a reasonable accommodation request. I was gonna see if opposing counsel can provide me with, I guess, any responses to that.
It was turned in anyways to Laura, but I don't know if she even said it to Brian or not. She probably threw it away like everything else.
Hey, hey Betty, could you hold on a second? Let me talk.
go
So,
ahead, Mr. Freeman.
So yeah, I guess just in between time, I was seeing if I can get the response from I guess she submitted a recent request. And it's my understanding that it might have been denied. So I just want the written response if it was denied.
I can
All right, well,
respond
you
now if
guys
you'd
will-
like.
Say that again?
I'm happy to respond now verbally, or I can
Yes,
email you.
Mr. Gromer, go ahead.
The issue in this case is an ESA animal is not a certified animal. There's a difference. It's the same reason that you can't go into a public space like a courthouse with an ESA animal, but you can go with an ADA animal. In this case with ESA animal, each animal has to provide a specific function different from the other one. That's the first part of the law. The second part of the law is that it has to be initially provide the paperwork prior to its admittance. In this case, the second request dog is for the same symptoms as the first dog, and it doesn't qualify. And I'll put that in writing to you, but, and I know she vehemently disagrees with that, but that's the
Warren,
law.
There's supposed to be a written response as well too, and she hasn't received that.
I wrote you on Friday, that written response. But I'll re-put it, I'll send it to you again, Mr. Freeman.
Okay. I know I
All right.
got your email, but not an actual written response. I'm saying.
We will continue this matter. I'm looking forward to like bamboo down my fingernails on the 29th of May at 10:30. Miss Bell, if you come here, you can't bring your dog.
I guess I don't show up then, do
Well,
I?
then, if you don't show up, you're subject to default, although your lawyer will be here, so he can represent your interests.
Like I said, justice system still sucks.
Well-
Up to Riverside.
Okay, then maybe you might want to consider moving somewhere else. But that's something.
No,
you can
Riverside's
discuss.
going down.
All right, Miss Bell, you're free to go.
So the
Thank
the
you.
29th will be the trial in
No,
person?
it's not the trial, you know, second hearing. We're gonna have a trial. We're gonna have to block out some time for this.
Okay. Is it okay if I appear remotely for the 29th?
Yes, it is.
Okay, thanks, Your Honor.
Same for you, Mr. Gromer. All right, Miss Bell, you're
you.
free to go.
Thank you, Judge. Thank you, Adam.
Thank you. All right.
All right, it is 138, our 135 case is Hinton versus Locus. James Locus is here. Are you Mildred Hinton? You're here as Chas. Which case are you here on?
Cassidy Henderson.
All right. That must be one of our general civil cases. Chastity Henderson, all right. Mr. Locus.
Yeah,
It looks like you're in the dumpster room of an apartment complex somewhere. Where are you presently calling from?
I'm in my room right now on my laptop. My room is a mess because I'm trying to get everything around so I can get it all moved.
Well, I don't see Miss Hinton. Are you at 714 7th Street?
Yes.
All right. Mr. Locus, you're a tenant in a landlord-tenant proceeding. Which case are you here on, ma'am? Okay. In such a circumstance, you are entitled to hire a lawyer. If you can't afford an attorney, you can see if legal aid would be willing to represent you in this matter or seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. To have a jury trial if you wish to. And if you wish to have a jury trial, you must file the written demand within 5 days and pay the $50 jury demand fee unless the judge waives it for your inability to pay it.
Okay.
And this is filed as a termination of tenancy. She simply wants you to move. If both parties think they could benefit from mediation, the court can refer it for mediation for an attempted mediated settlement. And perhaps a resolution could be reached with a conditional order of dismissal. We could assist in filing that motion. So, Mr. Locus, are you living in Miss Hinton's house?
Yes, my mother.
Yeah, it's your mother?
Yes.
All right. Do you have a lease?
No.
Do you pay any rent?
I haven't recently. because I have no job.
And your room is in the basement?
Yes.
Well, she's not here. Would you check and see if Mildred Hinton is checked in?
I'm pretty sure she's upstairs in her room.
Well, your room ain't looking too good.
No, that's because
Uh,
I've got everything like laying on my bed pretty much right now. Because I'm bagging stuff up and trying to get it out of here.
All right, so are you planning to move?
Oh, yes, definitely.
Well, normally I'm going to continue this. If she doesn't show up next week, I'm dismissing it. She missed her own court hearing.
Probably fell asleep.
I'm going to continue this to 10:40. On May 29th. If she shows up and if she gets what she asked for, you get 10 days from that day to vacate or be subject to being evicted. But that
On what
looks,
day you said?
you'd have 10 days from the 29th of May, which would be June 8th, to get your stuff out of there.
No, I said you said that you were continuing it. So what day?
Yeah, so our next hearing will be Friday, the 29th at 10:40 a.m. If she doesn't show up, I'm dismissing the case.
Okay.
If she does show up, we'll talk further about the matter.
Yep.
All right, Friday, the 29th at 10:40 a.m. You should get a new notice for that.
Okay.
All right, good luck, sir.
Yes.
Maybe you'll have that looking better when I see you next. Looks like the place in a movie where they slide down the trash chute and that's where they end up at the bottom. All right, I think that's the last of our landlord tenants for a minute, and this is where we shift gears to our general civil docket. We have two of those. We have Capital One versus Chastity Henderson. Miss Henderson is here. And we have LVND Funding versus Asia Kemp, and Asia Kemp is here in the courtroom with me. Ms. Fees, what case are you here on?
I'm here on the Capital One versus Chastity Henderson matter.
All right, let's talk about that one first.
Okay, should I begin, Your Honor?
Give me a minute to make my note here. I don't have your P number. What's your P number?
P76952.
This is file number 26147GC. It's entitled Capital One NA versus Chastity Henderson. The claim is for $7,306.68. The matter was filed. Defendant filed a brief answer, and the matter was set for hearing today. In the defendant's answer, let me flip to it. I wish to resolve the matter through a voluntary settlement agreement. The plaintiff has filed what's known as a motion for summary disposition, which is set for this time. Ms. Henderson, a motion for summary disposition is a hearing that the plaintiff claims in the pleading that there's no material issue of fact, that you have not stated any defense, and that a judgment simply enter in their behalf. In your letter, you indicate you're willing to discuss a resolution. Ms. Fees, are you willing to meet in a breakout room with Ms. Henderson and discuss that possibility?
I am willing to meet with her and see if there's something within my authority I can agree to.
All right, let me put you both in a breakout room. We did a lot of this morning. And Ms. Henderson, when the button come up that says join the room.
Okay.
Now, Ms. Asia Kemp is here on a LVNV funding matter. I don't yet see anybody on behalf of LVNV funding. So we'll hurry up and wait. And then that weird white cloud. What I'm seeing, the entire QR code is backwards. Now on that screen, it's not backwards, is it? Here's Andrew Katz. Ms. Kemp, why don't you come up here and have a seat, please? Has it started to rain yet?
Yes, that's what it sounds like.
Oh, it washes my windows. Seven, 8, 9, 10. Good afternoon, Mr. Katz. This is Judge Middleton here in Centerville. With us live in the courtroom is Miss Asia Kemp. File number in this case is 252248. Title of the case is LVNV funding versus Asia Kemp. Olivier and Olivier is the law firm. The claim is for $3,311.34 plus cost, interest, and attorney fees. Once the complaint was filed, the defendant wrote a letter. I, Asia Kemp, am responding to this case number. I'm not denying the debt. I'm acknowledging it, and I'm unable to pay on this large of an amount. So the plaintiff has filed a motion for summary disposition. You heard me speak about it a little bit in the last case. It is a motion that says there is, boy, it's really coming down. There is no material issue of fact, and you have not stated any defense. You've offered to discuss the matter. What I did with the last people is put them in a breakout room so they could discuss the matter privately. Mr. Katz, are you willing to meet with this defendant and discuss the matter?
Yes, Your Honor.
In a breakout room? Every time I meet someone like you, whose name is spelled like yours.
You know me.
Yes.
My maiden name's Davis.
Yes, and we've discussed the fact that your parents were Steely Dan fans.
Yep.
So, and so was I, or so am I. All right, I'm gonna ask the bailiff to take you out to one of the conference rooms,
Okay.
and the clerk will set it up in a situation where I can let you and Mr. Katz talk privately about this.
Okay.
It's raining real hard anyway, so you might as well stick around here for a
For a
while.
few minutes anyways,
So
right?
if you go with the officer, Michelle or Laura or somebody, would you set up the room for us?
Thank you.
Thank you. It is really raining. Wow. Hope the power doesn't go out again. As some of you know, we've had a rough spring. We lost power on a couple of separate occasions. It is really blowing. In the old courtroom, I didn't realize that there were no windows. I couldn't hear anything. It is just going sideways. Well, I hope the power doesn't go out again. We're tired of that. That's all right. I don't disagree with your, it was easier to just go with the flow. Yes, I don't have a quarrel with it. Well, I did put some down. It's been quite dry. However, Fisher Lake's gone down about 1 millimeter and it needs to drop a little bit. All the docks are underwater. This ain't gonna help. Is somebody doing the room? All right. I had to wash all the brick dust off my truck. They're working on the building and there's brick dust all over all the cars in the parking lot. Now we have hail. I don't know if you can see it. Well, I don't know what the problem is with the conference room. Must have a little difficulty getting it set up. Here we go. All right, Mr. Katz, I'm gonna put you and Miss Kemp in the second breakout room.
Okay.
And Asia, when that comes up, when all your dime dancing is through, you move to two. All right, very good. Our next landlord tenant matter is at 2:15, so we're not in any sort of a time crunch. I do have a criminal case I gotta see. And I've got some crunchy landlord tenant, small claims cases, including 2 with interpreters. Well, you're right. It's probably good for the grass, the flowers, and the crops. So I won't have to water tonight. Doesn't seem to be letting up any. Holy moly. All right, welcome back. While you've been in the breakout room, let's put another couple of litigants in a different breakout room. But let's return to Capital One versus Chastity Henderson. Ms. Fees, what's the status here?
We have reached a tentative payment arrangement, an agreement for a stipulated order.
All right, what are the terms?
Ms. Henderson has agreed to pay the full balance over 36 months, which would, her first payment would be on June 5th in the amount of $202.97, payable on the 5th of the month thereafter, until her final payment would be due, I guess it would be, it would be May 5th, 2028 in the amount of $202.73. If
What
at
is
any,
the amount? What is the amount of the judgment?
okay, so the judgment, well, the judgment would be for the damages, which would be $7,306.68. Plus the court costs of the amount of $149.72. However, if the defendant does pay per the agreement, we will agree to not collect the court costs and just collect the amount on the judgment. If at any time she does default on the payment, we do reserve the right to, request that the court set aside the payment plan and pursue the full remaining balance, including those court costs.
Ms. Henderson, do you hear everything that the attorney just said?
Yes, Your Honor.
And so you're going to try to pay this $7,306.68 debt in 36 installments. Is that the weather on your TV behind us, behind you?
The weather? Oh, no, that's just the my curtains. It has like a little bit of sunshine in the back.
No, over your other, behind you, looks like there's a TV with a weather.
Oh, yes, it's the news channel is on.
All right, showed a great big thunderstorm. We're seeing it here.
Oh, yes.
All right.
Yeah.
So, Ms. Fees is going to prepare what's called a settlement agreement, consent judgment, and she's going to submit it to me. Do we have your authority to show your signature that you consent on the record to that judgment?
Yes, Your Honor.
Do you feel like anybody unduly coerced you or threatened you to have you enter into this agreement?
No.
And this is by your own choice?
Yes.
And are you still at Ash Road?
Yes.
All right, Ms. Fees, could you prepare that order? You can email it to me at 3bcivil@stjosephcountymi.gov. That's the address that's on the notice, or you can just send it the old fashioned way. But if you email it, I sign it today.
Okay, and Your Honor, I do want to clarify, I did say she was going to pay over 36 months, but I did, the final payment would be May 5th, 2029, not 2028.
All right.
I did do that calculation wrong.
All right, May 5th, 2028. That's a pretty big
2029.
2029, yes. Now, let me say this, Ms. Henderson, I said this a couple times today. If you sell a car or you inherit some money or you get a big tax refund, nothing prohibits you from paying early on this if you want to just get it over with. But as long as you pay $202.97 per month, they can't pursue any other collection against you. And eventually, within 36 months, the matter would be resolved, which is pretty good. So you agree with those terms and conditions? When I get the order, I'll sign it and send it to you.
Okay.
Do you have any questions?
No, Your Honor.
Ms. Fees, anything further?
Just to clarify, you want me to sign Miss Henderson's name with permission?
Correct.
Okay, thank you. No further questions.
All right, thank you. Thank you for both being here in a timely manner.
Thank you.
Thank you. Have a nice
All
day.
right. We're working on it. All right. Ms. Kemp, would you come up and have a seat up here again? We return to LVNV funding. I'll remove you, Ms. Henderson. You can go on with your day. Oh, there she is. Mr. Katz is back. As I indicated, this is a claim less than the last one, 3,311.24. Mr. Katz, how'd you guys do in the breakout room?
No resolution, Your Honor. I would like to move forward with the motion.
He didn't even really give me an option. He started being very rude and upset with me when I asked a question. And then he hung up and dismissed himself out of the meeting from talking to me when I simply asked a question.
All right, well, let me go through this a little bit. The motion does appear to be appropriate. There is no material issue of fact, and there is no defense stated. So I'm going to grant it. What I would suggest you do, Ms. Kemp, is, and the bailiff will take you out there, is you file a motion for installment payments. I'm going to grant their motion and find, well, they sent me an order, but doesn't have any numbers in it. That's not very effective. Motion for summary addition is granted, but there's no number in it. Yes?
This 215 hearing, she has very weak internet and can't zoom in. So there's her phone number.
Elaine, can I give you these batch?
Yep, thank you.
And this is for Michelle.
All right.
So that order isn't very good. So let's back up here. The amount of damages requested is $3,311.34. Here comes the rain again. Mr. Katz, how much are you asking for? Let's take a look at the motion. Maybe that'll give me some guidance.
No, they were asking for, they usually ask for court costs, service fees, and the statutory attorney fee, which would be $75 in this case. The
motion's as bad as the order. There's no damages in it. The damages are $3,311.34.
Yes, Your Honor.
Which includes interest.
Which would be 4.72%. Here it is. We're asking for court costs and service fees of $151.55, statutory attorney fee of $20, for a total paid for of $3,482.79.
3408.
3482.
And again, what were the costs?
$151.45.
Let me see if I can doctor up this crappy order here. I can't, there's not enough room to write on it.
We can submit a new order, Your Honor. Is that
All right.
you? All right.
I'd ask you to submit an order, either by email under the 7-day rule. Did you dodge between the raindrops or you get soaked on the way in here? Oh, good. All right. Plaintiff will submit an order. Now, let me repeat what I wanted to say. You didn't get very far in discussion with him. Almost every case today, they worked it out. I put them in a breakout room and they came back with a mutually agreed upon solution. Apparently, that's not going to happen in this case. So when you get this order, you file a motion for installment payments, and then I can set the amount of the installment payments. We'll talk about where you're working, what your income is, what your expenses are. You heard the last case. There's Kleenexes there. They divided it into 36 months and worked it out. I had one today. It's going to take about 10 years to pay it off. At any rate, they can't do any collection activity on this for 21 days. And that's my advice, but the motion is appropriate. There is no material issue of fact, and there's been no defense stated. So I'll have the court officer take you out. They'll give you a motion for installment payments. Then you can look at that and file it. The order that they have me doesn't have any numbers in it, and there's not enough room for me to write these numbers in it. So he's going to submit a new number. Are you still on Prospect Street in Sturgis? Do you have any questions?
No.
I think the rain has stopped mostly. The time you're free to bug out of here. All right, advise defendant to file motion for installment payments. All right, do you have any other questions?
No, sir.
All right. I'll have the court officer take you out. All right, thank you. Mr. Katz, I'll see you next time.
Thank you, Your Honor.
All right, now we switch gears back to landlord tenant law. No, they're not tearing this building down. This was built in 1899 and it was in terrible disrepair. That was the same year I started here, 1899, and they refurbished it in 1996 and reopened it in 97. They stripped this building basically down to the bare brick and redid it. They preserved all the old woodwork, all those chairs are original, everything was redone, professionally refinished. And so it's been the county commissioner's chambers since 1997. But because of the construction in the building next door, the county commissioners have moved to the sheriff's training room and we're conducting court in this room. So it's a privilege for me to get to use this. It does have a terrible echo. Ms. Harris called about 2 minutes ago, Christine, and said she's having internet problems. So I don't like doing this, but I'm going to call her.
Oh, okay.
Was it raining really hard where you are?
Not where we are right now. It's black.
How
It
about
just
Mendon?
stopped raining here, but it poured pretty heavily for about 10 minutes straight.
Yeah, it poured very, very hard here in Centerville.
It did?
Yeah, very, very hard, 2 different times. Hope it washed all the windows. And this goofy background I have is your customer satisfaction survey. You scan that QR code and you can provide comments on what you think about this. Hello? Calling for Rachel Harris.
Christine Yancey there. Mhm.
Hi, Terry.
Hi, Christine. How are you?
I'm good. How are you?
Good.
Hello?
Haven't seen you in a while.
I know.
Mm-mm. I hope not. I don't think.
Leave a message. This is Judge Middleton calling for Rachel Harris for her court hearing that she's failed to appear for. All right, thank you. Bye. Well, the title of this matter is Fenrick v. Harris. The file number is 26705LT.
Oh, it's pouring down.
All right, go out and roll your windows down.
Yeah.
This is a property on Lakeview Street in Sturgis. Christine Yancey is appearing on behalf of the Fenrick LLC. This was filed as a demand for non-payment of rent. We had a hearing last week on May 8th. The matter was actually continued 10 days until today. She indicated she had gone to DHS to seek some emergency help, and I don't know what's happened since then. She called and asked the court to contact her, which I did, and I got her answering machine. Ms. Yancey, what's the status here?
Thank you, Your Honor. I submitted an updated judgment and a summary sheet. It's the same figures that we had on May 8th. We still have a partial payment that's due for March, and then we have April and May's rent and late fees, and the service fee, attorney fee, mailing fee, filing fee, all those stay the same. So we have $2,658.45. I have updated the judgment, Your Honor, and added today's date as the hearing date with May 28th as the date for payment or the application for the writ after May 28th.
All right, well, she isn't here. I'm going to try this number one more time. Hello? Hello? Hello, this is Judge Middleton calling for Rachel Harris.
My mom. Mostly my mom. I think my mom's a little bit here and there. A friend of mine.
Hello? I can hear people talking, but as far as I'm concerned, she's failed to appear. Excuse me, Paul sneaked up on me.
Give your mom a break. I think that was a part sneeze.
Christine, your judgments are always so good. Make our life easier. I find by default that through May, rent is $2,470. Court costs are $188.85. The date for the writ is May 28th.
Damaged tulips, living in trees. Can't even get what we already have for control. No,
Next is V squared V Hughes. Brittany Hughes and any other occupants. That matter is set for 2:20. So Brittany Poling is now in the room.
Until it stops raining. Down rains.
Miss Poling, can you hear me?
Yeah.
You're a little out of center there, but I can see you. This is V squared versus Brittany Hughes, now known as Brittany Poling. File number is 26759LT. Christine Yancey is here on behalf of the plaintiff. We were here again 10 days ago on May 8th, and the matter was continued until today. It's Ms. Yancey's contention that the rent is in arrears in the amount of $3,195. Ms. Poling, what's your response to that? Excuse me, I'm trying not to sneeze.
Oh, you're fine. I have half of that. I can have the rest of the rest of it within 2 weeks.
All right. Well, that's a start. I find by hearing that through May, rent is $3,195. There's other money due, which is $445.33, which is utilities. $325.93 for March, $60 for April, and $60 for May. There are also some late fees included in the rent figure. Court cost of $160.35. So the total is $3,801.28. So half of it is about $2,000. You have 10 days to pay that or be subject to being evicted. No money judgment is entered at this time, and a partial payment will not prevent the writ of eviction. Of course, when we get into June, which
It's another
month's rent will be due. So your landlord certainly will accept any payments that you make and apply it to the arrearage. If you can pay it within 2 weeks, that's more than 10 days from now. Your landlord can agree to work with you for up to 56 days from today's date to get this paid. 14 days from now will include June's rent. And the rent will probably entail another late fee.
Yeah.
So it's important you stay in contact with your landlord. Let me repeat, partial payment will not prevent the writ of eviction. You have to pay the entire amount. And again, your landlord can agree to work with you, but that's in their discretion. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. Are you working somewhere?
Yeah, I've been trying to pick up hours. So I switched from working 5 days a week to only 3 days a week, but I'm working 12 hours instead of 8.
Oh,
So
are
my
you still at
hours are a
Lake?
little different.
You're still
Yeah.
at Lake House?
Yeah.
All right. Do you have any questions?
No, well, so I've got 10 days, you said?
10 days to pay this or move unless your landlord gives you some additional time, which
Okay.
she has the discretion to do.
Okay.
This rent is expensive.
Yeah.
For what it is, and I find lots of people are struggling to pay it. Did you get put in under a program like Keystone or something, or just rent directly?
I just rent it directly.
All right. Well, the place was filled up immediately. Within a week or two of when it opened, they rented every unit in it. But for our purposes, the rent is pretty high and people are struggling to pay it, but people are struggling to pay all the rents. All right, do you have any questions, Ms. Poling?
No, I don't.
All right, stay in contact with your manager is my best advice.
Thank you.
Thank you, Christine.
Thank you, Your Honor.
All right, I'll remove Ms. Poling. She can get back to work. All right, Ms. Case and Mrs. Case, would you come up, please? This is Terry and Larry Richmond versus Shannon Case and Linda Case. Let me put it back on overall view. Shannon and Linda Case are present. Let me take this polling out. We were here on the 11th, which was 7 days ago. There were issues about heat and gas bills and other things. And we got kind of in the weeds. I think we determined, I'm not sure what we determined. $200.49. I'm not sure. What my note is, we're $830 in rent plus a late fee plus cost. Ms. Richmond, what's the status here today? Terry, you're on mute.
Okay, sorry about that. All they owe now is just part of the court costs, which is $169.09.
Too late. She got defaulted. First, I called once. There was no one there. I called the second time. I could hear people talking in the background. I left a message. So it's in there. So she needs to pay that amount. All right. Anyway, so as I recall, one of you is retired and one is still working at American Axle, and you have pretty good income. So according to this, all that's left due and owing is 169.09, but you guys didn't agree with that number.
No.
All right, what's your,
Well, when we got the paperwork and stuff.
could you speak up? I want to make sure
Okay,
the
is this
record.
the, is this the microphone?
Yes, it is.
Okay, I'm sorry. When we got the, paperwork handed to us, we had already paid the 11/32/34. And we got the paperwork handed to us a few days later, you know, via a person that delivers it. And, we called and spoke to the manager, Lydia, and told her that we had paid that, and shall we disregard this? She said, yes. Well, then, on the 22nd or 23rd, we got one mailed to us, a whole different one with a different amount.
All right, well, let's back up.
Okay.
You got the demand for possession. The Richmonds, actually, I'll give credit where credit is due. Terry Richmond does a very good job
Yeah,
in
Terry.
her landlord tenant pleading. She does better than many of our lawyers.
Yeah.
And so she tends to dot her i's and cross her t's when she files a case. So she filed a demand for possession for non-payment of rent. That's the first step.
Yes.
And that was dated March 7th. And it said you owed 1,132.34.
Yeah, and well,
All right, that's the number that you're operating from. You got a demand for non-payment of rent and you say you paid it. She filed this petition, or she filed that on April 1st. Apparently didn't move or didn't pay by April 1st, so she filed this complaint. Now apparently everything is paid. So that was served on you on May 7th. It said it was due within 7 days. So if you paid it, apparently you didn't pay it within 7 days. Boy, it's pouring again. So she hired the process server and filed the case. When did you pay the 1,132?
well, she says on this paperwork, it says that she filed the notice to quit for 11/32/34 on 3/7, which is what she said. Well,
Yes.
our rent wouldn't even be late until 3/8. Well, when we spoke to Lydia, we said that we would pay the 8/30 that we were behind, because I was off work for 3 weeks sick. And I wanted to pay it before our next month was due, which was $830. And we paid the
We
800.
may end up in the dark here in a minute.
Oh, no. I'm scared. But anyways, what our question is this $1,132.34, we were only behind in rent $830. We
Well-
paid the whole 11/32, thinking it was court fees too.
No, it was not.
That's what our question is, because we didn't know a gas bill. We don't have any gas. We still don't have a meter, sir.
All right, Miss, so
You
when
need
did
to
you,
call and order gas.
when did you pay on that 11/32
I paid on the 4th
of
of
April?
April.
All right.
yes. Because we didn't get this until, like I said, later. Or- I don't know why it would have been filed on 3/7. I think that's just a random date.
I thought the first two storms were bad.
Oh, no.
My wife was probably driving into this, so boy. Anyway, you owe the $169 and it isn't much, and you'll pay it and you'll start over again. So
We were coming back to find out what the 11/32 was total from the 8/30 that we owed in rent.
830 rent and 264.34. Let me see if I get that number. 830 plus a $40 late fee, 870 and 262.34. So the 262.34 was a gas bill, I think. What was the 262.34 that we talked about last week?
They were back gas bills. But if you don't have a meter,
No,
You need to call the gas company and get the gas in your name. Usually if they
that's-
take the meter, it's because the gas wasn't paid. And at some
No,
point
there's
you were
never-
paying.
I'm not gonna argue about it, but the gas we've never had gas. Like we didn't go all winter without gas. I don't even know why we would owe a gas bill. We have not had gas. They keep switching the meter on us. Larry will tell us one meter, Lydia will tell us another, and Terry told us the correct one. We finally got to talk to Terry and we got the correct one. And then I have message on my phone, you know, where the gas will be turned on. She said they would come. If we weren't there, then we'd have to pay a $50 fee. Well, we were there and the guy came out. Well, he was like, I gotta get permission from the landlord to come out here. This ain't right. You know, like there's 3 meters here. And I mean, it was crazy. We can't get them to do anything with the meters without the landlord's consent, they said, because they can't do that. And tell them what you talked to Larry. Linda talked to Larry. I'll let her tell you because I didn't talk to him about it.
oh, I tried explaining to him that that was not the correct meter, that I was gonna call the gas company, have them come out, and he said, no, they're a bunch of idiots, and I'll deal with the meters. So we said, okay.
And then next thing you know, there was another meter put up and it was like hissing gas and the beeper was going
Well,
off.
I've been waiting for the gas company to hook up a gas line in my house since last October.
We
Well,
had
we
it
had
though.
gas when we first moved
had
in
a
there,
meter.
I
but,
have gas, they're
but we
gonna
were
move the
paying
line.
it was actually, we were paying the neighbors gas. They've been evicted since then. And we paid Larry and Terry, we've got right here receipts of lots of gas bills that were supposed to have been in their name that we thought was our meter, but it was the neighbor's meter. And we paid it in full.
Let me see that.
That was the last time we got evicted. They said it was right, but it was past gas bill, so we got it caught up.
And it wasn't even really.
Every time we talk to Terry, things get smoothed out. That's why we tried to talk to her and get this straightened out. It's just dealing with too many people.
Yes.
I was out there Friday.
Oh, I work and we didn't know, so.
Yeah.
All right, that's true. I told you, she does a better job than many of our landlords.
Right, she does.
She wants. I mean, if she knows
All
what
right,
she's
I'm
doing.
gonna do this order and then you can meet with Miss Richmond and see if you can work this out, but I make the finding that,
But the
cost-
gas company will not come.
all right, well, that, you're gonna have to,
Without the
work. I
landlord.
can't do future stuff.
I mean, it was a cold winter. And now I'm gone 12 hours a day and Linda can't cook, you know, and I
Well, you
don't
need
want to
to
get into her
no,
health
there's,
issues, but
you
she's
need to
got,
get a gas
yes.
hookup in there.
And we pay our bills. We're not that kind of person.
We just want to know what we paid, what this 1132.34 consisted of. If we haven't had any gas and we paid our rent and the late fee, and we're not trying to get anything that we owe, we'll pay. Like, we've never in 50 and 70 years been evicted. Like, this is
No.
new to us.
No, as I said, you've got income. You've
Yeah.
always squared it away.
And we love our home.
Yeah.
That's not even the issue. We just.
And we
All
like
right, well,
Terry.
I'm gonna go with that number and then you can talk with her and see if you can further reconcile.
Okay.
Also, when that storm went through,
Oh,
it
yeah.
knocked out our window in the dining room or in the living room area. And we called and I left a message for Lydia and I never got a response.
I
It's
have
still
Lydia here with me if you want to get
That's
into this.
okay.
So is there also a broken window?
Yes.
I didn't see.
Right now, it's just taped.
I covered it up so that rain wouldn't get in and everything.
All
But
right.
Linda said she left. a
I don't know
message.
if they have a way to do a specific repair request. That isn't an issue now. What's issue is 16909 and you need to all get on the same page
Yeah.
and get a meter in there. And I agree.
Yes,
Go right
sir.
to the top and work with Terry on this. She doesn't want you to not have gas.
Right, I know.
And she doesn't want to get stuck with the gas bill.
No, of course
I
not.
paid the gas all winter. I don't know.
Yes,
And I
But it wasn't
called the
ours.
gas
So-
company today.
What was the gas meter?
It doesn't matter because we don't have gas. We haven't had it, so.
Well,
It happened sometime between this winter and now. Because Lydia
Well,
was
that's why we
out
need
there.
to sit down with the
it
mediator.
needs to get fixed. And if you guys all are on the same page.
Yeah.
All right, that's due within 10 days from today, which would be May 28th, 26. All
That's the way
right.
it goes.
I'll just leave it at that. You get a hold of Miss Richmond. I want you to get the gas squared away and you can discuss this number, but I trust her number closer than yours. And we'll see where this goes. I'm
So
not
we,
gonna sign any writ of eviction
So
until we
can we
have.
set up a time to meet with Miss Richmond or something right here in the court? 'Cause we can't get a hold of anybody at that
All
number.
right.
You don't leave messages. If you're calling, you're not leaving messages.
All right, now, would there be,
Huh? What happened? He might have. Nobody's moving there. Well, we might be done. They have a generator.
I can hear you.
Can ya?
I can't. I've lost my Zoom feed. Wow, this is weird.
Can you hear me?
Yes, I can hear you. Can you see me?
No, I can see the girls, but I can't see you.
Well, I could change it to me. But we've lost part of our signal. Mr. Buckland, can you hear me?
Yes, I can hear you.
I'm not even sure what we're connected to, but,
You have a generator, don't you?
well, the power is back on. It flickered off, but it powers the IT computer equipment. Let's see if I can get this reestablished here. I don't want to completely just get this part out. I get nervous. If you take them out to the counter, they can get a copy of it. I was gonna try a breakout room, but the system is out of whack.
Will we get a mediator there or just be between us?
Just between the two of you.
Then do we, if we feel like they owe us money, then we can.
So you could
same
file a
thing they
small
did?
claims action.
Okay. All right, thank you, Judge.
Okay. The tornado siren is going off.
Oh dear. Did you hear that? Tornado sirens going Centerville.
I think that's what it is.
Well, it's not new.
Maybe not. Might be something else. No, it's the Javs equipment. It's not a siren. It's the stuff spinning in place. The problem is, I don't know if your defendants can get here. We have Esmond and we have Mr. Hudson. Unable to connect. I've never been connected in this fashion.
What's wrong? I better keep them.
I think this is the corollary of 2 tin cans and a piece of string.
Are they gone? Are the girls gone?
Yes.
Okay.
I would have attempted a breakout room, let you guys talk to each other, but I don't have the current ability to set it up.
Yeah, it's fine. They can just call me. But we write down every message that comes in.
It's not terribly far apart, but I agree. Everybody needs to be on the same page. I would be inclined to issue defaults on each of your defendants, but I don't know whether they can connect. It's also gonna affect all my landlord, my small claims cases. Yeah. The phone is out.
Call the gas company and talk to them. The only reason it's off now is because I turned.
Yeah, no dial tone.
So if they didn't use their furnace, well, no, that's not that. The gas is not freaking. I know. I was just gonna get all these rounds in order. What's his phone number? So there'd be.
Maybe I can start it again. Let's try this. All right, I got people in there.
Some of those are from 24.
All right, let's see who we got. Phone, Richmond, Buckland, Court.
The 2293 is my other one.
Could be.
Hmm?
Could be.
All right, who is 2293? Is that
This is
Mr.
Robert Esmond, Your Honor? Yes, sir.
All right.
What did I do with my pen? Didn't write down how much.
And who is iPhone?
Caitlin Hacker.
What case are you here on?
The, oh, hold on one second here. The Vasquez Hacker.
All right, that's a small claims case. You're all right. We'll come back to that.
Okay.
All right, Miss Richmond, let's take up your case.
Okay.
This is Terry and Larry Richmond versus Robert Esmond. We determined last time rent through the 14th was $964. I think it's probably gone up.
Yeah. Right now he owes $1,171.77 in rent. Court costs of $175.63 with a total of $1,347.40. That is through the 21st.
Through 5/21. All right.
Yeah.
Mr. Esmond, do you agree with that or disagree?
No, I agree with it, Your Honor.
All right. Do you have a plan to pay this?
Yes, I planned on doing something Friday and I had unexpected circumstances pop up. I am getting some money tonight to drop off tomorrow after work. And I will have some Thursday morning and the following Wednesday after work sometime when I get paid.
All right. Sounds like you got a plan. Through May 21. Rent is $1,171.77. 171.77. 117,177 plus 175.63 in costs for a total of 1,347.40.
Yes.
That's due within 10 days, which would be May 28th.
Okay.
No partial payment will not prevent the writ of eviction. You could be liable for additional money damages if additional weeks pass and no money judgment is entered at this time.
Okay.
You have until May 28th also to appeal this. All right, it sounds like you got a plan to pay it all. Stay in contact with your landlord and you should be good
Terry,
to
I
go.
will get a hold of you tomorrow after work.
Okay, thanks. See you then, Robert.
You're welcome.
All right, very good.
Thanks,
All right,
Your
you
Honor.
guys have a great day.
Thanks, you too.
All right. Our last landlord tenant matter of the
Thank you.
day is, thank you, Terry, is Ron Cerny versus Aaron Hudson. This is file number 26727 SP. This matter was continued from last Monday to this day. Mr. Hudson did not appear, but there was discussion that he was going to quit claim the property back to Mr. Cerny. Mr. Buckland, what's the status here today?
He did sign a quit claim, judge, and so we've sent that over to be recorded. So I think we're in a position where we would just be dismissing the matter.
All right, plaintiff will dismiss. If you send me an order of dismissal, that would be great.
I'll do that.
All right, very good. Thank you. I'll see you next time.
All right, have a good week.
Okay. Hi, Judge Middleton calling. We had a power blink over here, but I think we're back up. Could I see Vance Long in my courtroom? All right, thanks. Bye. Good afternoon, Mr. Stickley.
Good afternoon, Judge.
All right, I tried to squeeze this matter in at 2:45. I've got some landlord or some small claims cases that start in just a couple minutes. We and afternoon. This is a violation of a no contact order of a bond condition. The person he was not supposed to have contact with slapped him allegedly, and she got arrested. He is represented by Attorney Ross Truckee and is set for a last pretrial for June 11th. Are you Vance Long?
Yes, sir.
This is Judge Middleton. I'm here at the courthouse. I've got this weird funky background thing here because the state is conducting a satisfaction survey, but I think maybe you can see me on the other feed. You got arrested last night for violation of a no contact order on your bond. With us, you can see him on the screen as Mr. Keith Stickley. He's the Chief Public Defender for St. Joseph County. You were alleged to have assaulted Arlie James, your girlfriend, and that was alleged to have occurred on May 13th of 2026. You pled not guilty to that April 13th. There was a final attorney pretrial. You continued your plea of not guilty. The matter is set for an attorney pretrial with your lawyer, Mr. Ross Truckee, for June 11th. I'm going to put you in the waiting room while you wait for your small claims case. That ceiling fan's kind of driving me nuts. She's chomping away on the gum. We'll set her aside for a minute. Anyway, she got arrested for assaulting you, and she's in jail, and you got arrested because you weren't supposed to be there in the first place. So the question I have to decide is, am I just going to leave you in jail until June 11th? I'm going to let you out on some sort of a bond. Are you employed somewhere?
Yes, sir, I am employed.
Where's that?
It's at Precision Wire, sir.
When did you start there?
I started there, I got released from here actually, first time. So I think that was, April 13th. I'm not terribly sure.
Laura, would you confirm that he's employed at Precision Wire? Where do you live?
I live at 218 North Lincoln Avenue, Three Rivers, Michigan. With my father.
Where does she live?
She lives at, I believe, 1228 Javier Drive, and that's with her mother.
All right.
Yes, sir. Yes.
Someone called the police while you guys were in the TSC parking lot, said you were fighting inside the car. Then you
Yes,
took
sir.
the fight to Wendy's drive-through and the cops got there and it was still not going very well. What?
Allegedly.
Allegedly. So it was a clear instruction that you weren't to have any contact with her. So
Yes, sir.
how do I know if I let you out of jail, you're not going to continue to blatantly violate the court's order?
Well, that's because I want nothing to do with any trouble. I want to, as I said, I want to get my life on track. And the reasoning that I was with her in the first place.
But don't tell me
don't
about
get into
that.
that. Stop.
Laura, I don't know if you heard me. I hope you did. Anyway, you weren't supposed to be, and it violates your bond. So I could cancel your bond and leave you in jail. I have to give you a bond within 28 days. You have a hearing set for June 11th.
Yes,
And
sir. I would greatly appreciate it. Do not leave me in here. And I would do everything right. It was just a misunderstanding at that time. Yes, sir.
well, there was, all right, let's get clear. You're not to have any contact with her. Now,
Yes.
she's
I
charged with
understand.
assaulting you. So she
Yes, sir.
also has an order not to have any contact with you. If you're telling me
sir.
the truth about working at Precision Wire, I'm gonna give you a, what shift are you on?
Second shift, sir. I am scheduled today at 3 p.m. to, I believe, 11:30 or 12:30 p.m. And I'm working, I got moved to seat frames.
All right, I'm gonna reinstate your bond. I'm gonna set a bond violation hearing
Yes, sir.
for June 11th
Yes, sir.
at 2 o'clock with your last pretrial.
Yes, sir.
That's a contempt of court, even if you're found not guilty of the principal charge, you could be found guilty of contempt for violating the order for no contact. Anyway, I'm gonna let you out of the jail with explicit instructions, no drugs, no alcohol, no threatening behavior, and no contact with the complaining witness, who is Allie James. You understand?
Sir. Yes, sir. I fully understand. I fully understand.
All right, you're good to go. Thank you, Mr. Stickley. All right, so let me remove the jail. All right, we've got some small claims matters, which are supposed to start in 4 minutes. Let's take poll and see what we've got. What's your name, folks? Which case are you here on? What? All right. Cheryl Harmon versus Cindy Suter and Dwayne Suter. Cindy Suter is here.
Good afternoon.
Good afternoon.
Good afternoon.
All right, right now I'm just trying to line up who's here. I don't like it when people come in by telephone only. It's hard to figure out who we've got. Someone is here by telephone. It ends in 2653. Who is that?
Your Honor, that's the interpreter. I'm having trouble with my Zoom application right now, and so that's why I joined by telephone.
All right, well, we'll do the best we can. All right, I'm gonna take a moment. I just dealt with an in custody defendant. I need to take that file out to the clerks. So I'm gonna be back in about 2 minutes and we'll take these up one by one if we can. We'll shut the record off. The live feed is still on.
No puedo apagar la cámara. No puedo apagar la cámara.
No le iba a poner en silencio.
¿No está en silencio? Sí.
No sé. Como dices que tiras entonces.
Ok, va a ser una interpretación. ¿De verdad? Ay, no.
Y creo que habíamos puros americanos en las cámaras.
Just wanted to let you know the record is still on, so any conversations you're having is being recorded.
Siguen grabando en actas. Cualquier cosa que digan se está grabando en actas.
All right, the record is off. I'm gonna turn it back on. See who all we've got.
Las actas están apagadas, voy a volver a encenderlas a ver qué tenemos.
Is Brandy Carson here? Colorful Roots. She's joining us. All right, Miss Carson, can you hear me? Are you Brandy Carson?
Yes, I am.
All right, can you hear me?
Yes, I can.
All right, we have both parties here. Mr. Jason Bailey is here from Stellantis. All right, let's see who else we've got. Cheryl Harmon is here, and Cindy and Dwayne Suter were here. There they are. They're both present. Sylvia Ramos Vasquez versus Caitlin Decker. Is anyone here on behalf of Sylvia Vasquez?
En el caso de Silvia Ramos Vázquez, hay alguien que está presente para este caso.
Is Caitlin Decker here?
Last name is Hacker, though.
Hacker, all right. Please take your gum out if you would.
Okay.
I've got her. All right, Caitlin Hacker.
Yes.
We don't have the plaintiff in that case. We have someone here named Angie. Angie, which case are you here on?
I'm here with Brandy Carson. My name is Angela
All right.
Folk.
All right. Then I have Lorena Maldonado. And I believe he's here on TR Auto Salvage. Mr. Maldonado, can you hear me?
Yes.
Señor Maldonado, ¿me puede escuchar?
Sí.
Do you require the services of an interpreter?
¿Requiere los servicios de un intérprete?
Sí.
Yes.
No one is here from TR Auto Salvage.
No se ha presentado la otra parte de TR Auto Salvage.
We're going to set that case aside for a moment. So we
Vamos
don't
a poner
have,
para un lado, vamos a apartar este caso por un momento.
Okay.
we don't have Sylvia Vasquez, and we don't have TR Auto Salvage. So we're going to set those aside for a minute. We have both parties. Vivian, you don't need to translate these until we get into their cases.
Okay, all right.
So we will take up Brandy Carson versus Stellantis Motors. The file number is 26682SC. Ms. Carson has filed a small claims action requesting $6,244. This is typically not the kind of case that we filed in small claims court. As a result of a defect in Stellantis Corporation's vehicle brakes, I almost lost my life and suffered damages by losing my vehicle, work opportunities, I had to close my shop due to financial issues as a result. Mr. Jason Bentley is here on behalf of Stellantis. Mr. Bentley, what's your position with Stellantis?
Your Honor, our position is that this is not a manufacturer's defect. This is more than likely an issue that needs to be taken up with their insurance company based on her request for.
What is the CRM?
Oh, that's customer relations manager.
All right.
So my position at the company.
Is this the type of case Stellantis is going to move from the small claims court to the general division of the court?
To be honest, I have been discussing with our legal team. We were kind of surprised to see this being taken up in the small claims court as well. At the end of the day, I guess it's up to Brandy Carson on the outcome of this and what she wants to do.
All right, well,
but our
I'm
stance
surprised.
Yeah.
I don't choose which cases are filed here. You're about to go to trial on a claim for $6,000. You're not an attorney. You don't have to be an attorney in small claims court. You have a position that's not a manufacturer's defect. You have no expert witness. She's going to testify, and she's got a witness here to testify. And you run the risk of having a $6,000 judgment against you. All you got is you and hearsay. I don't select the cases that are filed. They get filed. It was served. You've accepted service, and you're here. She's prepared to provide evidence and testimony in support of her claim. You got you who says, hey, we don't believe this is a manufacturer's defect. Your legal team didn't say they were going to remove this. They were just going to leave it as a small claims case.
Unfortunately, it was sent through our call center. It was sent to me, and I received it about a week ago. So I was kind of surprised as well, but I figured it's still
all right,
important
well,
to
let's
attend.
table that case for a minute. No one else has come in here.
Your
Senor
Honor.
Maldonado.
Yes.
Vivian, I'll use your services here.
Okay.
This is file number 25111SC.
Este es el número de caso, señor Maldonado. Número de caso 25111SC.
Joining us is certified court interpreter Vivian Montero.
Uniéndose a la audiencia es Vivian Montero, intérprete certificada.
I'm going to take a moment and swear her in as a interpreter.
Voy a tomar un momento pedir que ella preste juramento como intérprete.
Do you swear to the best of your ability you will interpret these matters from Spanish into English and English into Spanish?
I do.
And are you Lorena Maldonado?
¿Es usted Lorena Maldonado?
No, me llamo Luis Alba.
No, my name is Luis Alba.
Luis ALVA?
Yeah. A-L, B de bueno, A.
Es B de vaca.
A-L-V as in Victor A.
TR Auto Salvage, which is also known as Eagle Auto Parts,
TR Auto Salvage también se la conoce como Eagle Auto Parts.
filed a lawsuit against Jimena Auto Repair in Fort Wayne.
Entabló una demanda contra Jiménez Auto Repair en Fort Wayne.
Jimena Auto Repair did not show up for the hearing.
Jimena Auto Repair no se presentó para la audiencia.
Ok. Yo tengo un año que adquirí la compañía y no tuve conocimiento de que me tendría que presentar a una audiencia.
I acquired the company 1 year ago and I wasn't aware that I had to come to a hearing.
They sued Jimena Auto Repair.
Ellos entablaron una demanda contra Jimena Auto Repair.
Sí, yo no tengo ningún problema en pagar ese deudo, simplemente no tenía conocimiento.
That's fine. I have no problem paying the debt. I just wasn't aware of it.
All right. You owe one. Trying to figure out how much it is.
Tengo que averiguar cuánto es.
You owe, we also did a discovery subpoena and you didn't show up.
También emitimos una orden de comparecencia para intercambio de pruebas y usted no compareció.
There is a warrant for your arrest for $2,200 for not appearing at the hearing.
Hay una orden de detención pendiente por $2,200 por no comparecer en la audiencia.
Your company bought some supplies from Greenlight or Eagle Auto Parts.
Su compañía compró unos suministros de Eagle Auto Parts.
And the check bounced.
Y rebotó el cheque.
So the amount due is $2,200. Are you willing to pay that?
El monto pendiente son $2,200. ¿Está dispuesto a pagarlo?
Mi comentario es que cuando se hizo esa compra, la compañía no era mía.
The question is, when this purchase was made, I had not acquired the company yet.
All right, then let's talk about that.
Entonces vamos a hablar sobre eso.
Okay.
All right.
The company they sued was Jimena Auto Repair.
La compañía al cual demandaron es Jimena Auto Repair.
Correcto.
Right.
And you claim your business is Jimena Auto Service.
Y usted alega que su compañía se llama Jimena Auto Service.
Correcto.
Right.
So is it your testimony that, first of all, I'm going to ask you to raise your right hand.
Por favor, levanta su mano derecha para prestar juramento.
You swear or affirm any testimony that you're about to give in this matter will be true to the best of your knowledge and belief.
Usted juro o afirma que cualquier testimonio que presenta en este caso será verdadero y correcto a su leal saber.
Acepto.
I accept.
Did you purchase auto parts from this company?
¿Usted compró piezas de esta compañía?
No.
No.
It's very confusing when you open a company with an almost identical name to the previous company.
Es muy confuso cuando uno abre una compañía con el nombre casi idéntico que el anterior.
Then they went out of their way to personally serve you with this in Pontiac or in Fort
Y
Wayne.
luego ellos fueron hasta Fort Wayne para entablar la demanda.
Then you promptly ignore it and a default
Y
enters.
después usted lo ignoró y entonces hubo una decisión que se tomó por incomparecencia.
Then they serve a discovery subpoena on you and you don't show up for that.
Y luego le mandaron una orden de comparecencia para el intercambio de pruebas y usted incompareció para eso.
Now, well after the fact, you file a letter and say, hey, it wasn't me.
Y mucho más tarde usted dice, oye, y manda una carta y dice que no fui yo.
Who is Jimena Auto Repair?
¿Quién es Jimena Auto Repair?
Es mi socio, era mi socio. Ok. Yo
¿Es su socio?
no soy el dueño de Jimena Auto Repair. Trabajé un tiempo con Jimena Auto Repair. La compañía cerró y yo abrí mi negocio como Jimena Auto Service.
Stop.
Okay. I worked for Jimena Auto Repair for a time. It got closed down. And then I opened my business, which is Jimena Auto Service.
At the same location?
¿En la misma ubicación?
Es correcto. El nombre de Jimena Auto Repair aún seguía en el taller. No lo quité en el momento para no perder clientes.
The name Jimena Auto Repair, the sign stayed up on the business. I left the sign there so as not to lose clientele.
¿Qué le digo? Que quiero pagar, güey. Ahora, lo que quiero aclarar es que no se está negando, no estoy negándome a pagar ese saldo, porque al final de cuentas no quería que hubiera, pero nunca me llegó un citatorio de lo que me están diciendo para pruebas de que no era mi compañía o que sí era mi compañía.
So I'm not saying that I'm not paying the amount, but the truth be told, I never received any notification that I had to come to court.
Yo solo quiero ver la manera de cómo saldar y no tener ningún problema.
I just want to see how to resolve this so as not to have any further problems.
The check was dated September 5th of 2023.
El cheque contenía la fecha del 5 de septiembre de 2023.
No sabría decirle, no estoy muy seguro de esos datos yo.
I'm not very certain about the information. I'm not sure about it.
It's signed Jimena Auto Repair LLC.
Está firmado Jimena Auto Repair LLC.
And the check was returned as non-sufficient funds.
Y el cheque fue devuelto por fondos insuficientes.
You're continuing to do business at that location under the same name.
Usted sigue realizando trabajo en la misma ubicación bajo el mismo nombre.
No, es a nombre de Jimena Auto Service.
No, the name of the business is Jimeno Auto Service.
The sign on the front says Jimeno Auto Repair.
El letrero en la parte de adelante dice Jimena Auto Repair.
Es correcto, no lo he podido quitar.
That's correct. I have not taken it down yet.
Jimeno Auto Service LLC is a company in the state of Indiana.
Jimena Auto Service LLC es una compañía en el estado de Indiana.
Sí.
Right.
It was incorporated in August of 2024.
Fue incorporado en agosto de 2024.
Correcto.
Correct.
This bill was incurred in 2023.
Esa factura se hizo en 2023.
No lo sé.
I don't know.
You filed a motion to set aside the default, and I'm going to grant it.
Usted presentó un pedimento para suspender el hecho de que usted no se presentó o por incomparecencia y voy a concedérselo.
Who is the owner of Jimena Auto Repair?
¿Quién era el dueño de Jimena Auto Repair?
Mi hermano.
My brother.
What is his name?
¿Cuál es el nombre de él?
Miguel Ángel Alba Jiménez.
Miguel Ángel, last name Alba Jiménez.
I don't like this one bit.
No me gusta esto para nada.
You ordered almost $2,000, or somebody ordered $2,000 worth of product from our store in Three Rivers.
Alguien mandó a pedir $2,000 de productos de nuestra tienda en Tres Ríos, en Three Rivers.
And bounced a check.
Y el cheque rebotó.
Then played fast and loose with the ownership of the business, maintaining a nearly identical name.
Y luego hicieron un cambio rápido, manteniendo casi igual el mismo nombre.
So the default as to Jimeno Auto Repair, they were not served with it.
Entonces, Jimena Auto Repair no lo recibió.
I don't like it one bit. These people got
No me
cheated out of
gusta esto.
$2,000.
No me gusta esto para nada. Estafaron a esas personas de casi $2,000.
And they aren't here to contest it.
Y ellos no se han presentado para refutarlo.
Otherwise, I might not grant it.
De lo contrario, quizás no se lo concedo.
They can start over again and sue your brother.
Ellos pueden empezar de nuevo y pueden demandar a su hermano.
You're free to go.
Ya se puede retirar.
Ok, gracias.
All right, thank you.
I think I have a proposed order in here.
Is there anything else for the interpreter, Your Honor?
Yes. We have another interpreter case, but the plaintiff did not appear.
Okay.
That is Silva Ramos Vasquez versus Caitlin Joe Hacker. No one is here on behalf of Silva Vasquez. Caitlin Hacker is here. This is a claim for $2,278. Where the defendant allegedly damaged her car in a parking lot. But she isn't here, so I'm going to enter a default judgment against the defendant without prejudice. I'm against the plaintiff. Case dismissed, plaintiff failed to appear. When the defendant fails to appear, a default judgment enters against the other side. Same thing happens when the plaintiff doesn't appear. Ms. Hacker.
Yes.
Apparently you bashed into these ladies' car in the parking lot and caused a couple $1,000s worth of damage. They aren't here to perfect their claim, so the case is dismissed without prejudice. Meaning it could be rebrought if they have a legitimate excuse for not appearing.
Okay,
But you're free to go.
thank you.
All right. That finishes your obligations, Vivian. Thank you.
All right, thank you, Your Honor. Have a good day.
Got a few miles to go before we get to the finish line, but all right. Let's next address Cheryl Harmon versus Cindy and Dwayne Suter. Ms. Harmon, would you come up and have a seat? That's water. All right, we have two cases pending. Harmon versus Suter and Carson versus Stellantis Motors. You're all here in a small claims case. In small claims, the rules are different. I'll leave it on this for now. The rules are more relaxed. There's no strict adherence to the rules of evidence and procedure. Neither party is entitled to be an attorney unless they're suing on their own behalf. There's no appeal from small claims court. Any decision made here is final. Either party has the right to remove the matter from the small claims to the general division of the court. But you have to tell me before we begin. Once we start, any decision here is final. Ms. Harmon, do you understand?
Yes.
Mr. Suter, do you understand?
Yes.
Ms. Suter, you understand?
Yes.
All right, we'll get to the next case in a minute. This is a lawsuit for $4,415. Mr. and Mrs. Suter, I want you to raise your hand, and Ms. Harmon, you as well. You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Yeah, yes.
All right. Ms. Harmon contends that she lent you guys a large sum of money and they're still due and owing $4,415. What's your response to that?
I do owe her that. Yes, absolutely.
All right. All right, how do we get the case back on track? Can you make some sort of payments on this?
If I can do like $500 a month, I can manage to do that.
So you would continue to pay this at $500 a month?
Absolutely.
All right, I find by consent that the plaintiff is entitled to $404,415. They didn't put any costs in here. Excuse me. I'm not sure why not. Maybe they're waived. Payable at $500 per month.
I'll keep you first.
When can you start? June 1st or June 15th?
We can't do it on the 1st because we get paid like once a month at the end of the month or middle of the month, somewhere around there.
I'll do it June 15th.
We can make it on like the 20th of the month. That would be great.
All right, June 20th.
We can start that next month. That would be even better.
All right. I find by consent that the defendant owes the money, agrees to pay it $500 per month starting June 20th of 2026 and the 20th of each month thereafter. Ms. Harmon, they agree they owe you the money. They're going to start paying at $500 a month, which is pretty good. It'll take about 9 months at this rate to pay the balance off, but that's a substantial payment. So now you pay directly to her. I would direct you to pay either by certified check or money order. That'd be my recommendation rather than cash. And keep track of it. At this rate, it would take about 9 months to pay it. All right, think she brought me a clean copy. Yes, thank you. All right, I'll have the bailiff take you out to the court office. The clerk will give you a copy of this. If they don't make payments, you can ask the court for what's called a discovery hearing, and we'll compel them to come in and figure out what's going on.
Great.
All right, thank you. We had about 6 cases scheduled today, and the translator cases take a long time, but we've worked through 5 of them. And what's left is entitled Brandy Carson versus Stellantis Motors. Mr. Bailey, would you rejoin us, please?
Your Honor, am I okay to leave?
Yes.
Thank
Ms.
you.
Suter, thank you. All right, would you each please raise your right hand? Angie, if you're going to testify in this, I'm going to ask you to raise yours as well. But at this point, Joe, please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Swear.
I do.
All right. Ms. Carson owns a business called Colorful Roots. And she sued Stellantis as a result of an automobile accident. This is small claims court. It's not general civil court. And there are certain things you can sue for and certain things that you can't. You can sue for money damages for damage to your car. You can't sue for a tort like intentional infliction of emotional distress or some of those things. In your claim, it's quite brief, but you've attached a lot to it. I'll read it. As a result of a defect in Stellantis Corporation's vehicle's brakes malfunctioning, I almost lost my life and suffered damages by losing my vehicle, work opportunities, had to close my shop due to financial issues as a result. I'm asking that debt be cleared to be reimbursed, I guess it is. So, Ms. Carson, how did you come up with this figure of 6,244?
Yes, so the figure that I have is actually higher than that, considering that my insurance premiums went up from $200 a month to over $500 a month as a result of the accident. So that total amount is actually $3,806.42. The
All right,
5,000.
give me that. All right, stop. That amount, give it to me again, 3,000?
Yes, sir. It's $3,806.42.
And that is for your increased insurance rates?
Yes, it went from $207, which I have the documents there, over $500 a month as a result of this accident. That was not my fault.
All right, there's 3,806 of the claim. What is the rest of it?
So the $5,000 is a $5,000 deposit that I put down on the vehicle to purchase the vehicle. I had the vehicle less than 2 years, and I no longer have the vehicle due to the brake defect, where I had no control over my vehicle other than to steer it. And that's how I ended up crashing into the tree at the base of River Road, headed towards downtown Three Rivers. The $1,244 is the cost that I spent to get rentals in order to still try to maintain business. I had a shop that I opened in 2016. downtown Three Rivers that I ended up having to close because I needed to make financial decisions to stay afloat. And I do have the document, I think you have it included, where it does show the insurance deemed the accident not my fault. It was a mechanical technical issue that happened with the vehicle where the brakes were frozen and
All
I
right,
could not.
refer me to that. You filed
Yeah.
pleadings that are very small print and I can't read them.
Yep, I've got this. You should have is the letter from auto owners insurance stating that the accident was not my fault.
All right. Please be advised that the above referenced claim involving a 2020 Jeep Grand Cherokee on April 6, 2025 was deemed a not at fault accident. Should you need additional information, please contact. So not at fault is different than saying there was a defect with the brakes.
Yes, Your Honor. I had a mechanic inspect my vehicle and it was deemed a defect. Also, I included information.
Stop.
Sorry.
Where is that?
I think I have the check showing where I paid for that. And it wasn't, Your Honor, it wasn't just an accident. I hit the tree and the vehicle actually continues to accelerate afterwards. That's the nature of the defect. So the vehicle kept going even after hitting the tree.
All right, but where is your expert that says this was a result of a defect with the vehicle?
I have the check. I was not able to get him to come here, but I have the check there showing that I paid him to inspect the vehicle.
All right, well, who is that?
It's the cancel check, well, not cancel check, but the check should be there. I also included statements from other people that own a Jeep that had the same exact experience. And I have the pictures showing how the vehicle worked itself out of the dirt and kept going.
All right, well, you're claiming this was a result of a defect from Stellantis Motors. This car is 5 or 6 years old at the time of this accident. You had owned it for 2 years. I can't tell yet how many miles were on it or what the service record of it was. But you have to establish that there was a defective product. Usually this isn't done in a small claims case. You gotta do more than throw spaghetti at the wall and hope it will stick. So who is your expert to say that this accident was a result of the brake defect?
The insurance company did the inspection and that's how they discovered that it was not fault.
Where is that?
I have a separate case with them. They did not supply me with the actual detail of the information, but they said that they agreed that it was not my fault.
So you also have a separate claim against the insurance company?
Yes. And if you look at the pictures, you can see where the vehicle impacted the tree, and then you can see how it kept going. And then if you look at what I included from testimonies of people that had the same exact situation happen, all that should be in there.
I'm familiar with this intersection. Drive it frequently. It is a sharp curve to the left. River Road comes in. At one time, there was a bridge there, the Wood Street Bridge. You weren't born yet, but you could cross in front of the dam to Wood Street. And that would take you from Second Ward into Fourth Ward. I can see that you apparently went through the grass at the plant for quite a distance. There's a dam there, which is run as a hydroelectric dam.
Yeah. Your Honor, the vehicle just kept going. The only way I was able to stop the vehicle was to force it into park. Had I not been able to force it into park, I would have ended up in the St. Joe River.
All right, well, so that may not be a brake defect, it may be a throttle defect.
Well, the gentleman that I had look at my vehicle, he looked at it and he said it was a computer issue. I also went back and forth in communication, which I do have documents of that with the insurance company where they questioned the brakes, and I showed proof, which I have included in there, that the brakes were checked. So there was nothing wrong with the brakes. I literally could not, the brakes were frozen. Usually you can push down the pedal in order to brake. It was frozen, totally deactivated. After that situation, I looked to see if I could find recalls, and I came from situation after situation after situation where the same incident happened with several people with their Jeeps, where the brakes were deactivated and they couldn't. Some of them crashed into the lake in one incident. Another person crashed
All right,
into.
well, that's all hearsay. So now I also have auto owners, and then I also see Progressive. That's when your insurance went up, is that correct?
Yes, my insurance premium went up as a result.
What's your lawsuit against auto owners?
Well, really, I would like to just get things settled with Stellantis because I talked to them earlier today. They said that the reason why my insurance said that it was the reason why it was listed or reported as me being at fault was because Stellantis listed me as fault and not them. So that's why my insurance went up.
All right, at 8 o'clock in the morning on April 7th of 2025, they were dispatched to 401 8th Street for a dam employee requesting that the vehicle be removed from the property. It's not clear what time the accident took place. I arrived on the scene and the caller, Clements, had left. He explained the vehicle had been sitting on the grass and he would like to have it removed. I advised Clements the vehicle could be removed. It was on private property. He assured me the vehicle was on the hydro dam property. He additionally returned to the scene to sign authorization to remove the vehicle. I made contact with Brandy Carson, who was aware her vehicle was on the property. When Carson stated she was driving the car the night prior, so sometime previous evening is when the accident happened. Carson stated she had walked home and planned on having the vehicle towed in the morning. That's called leaving the scene of a property damage accident, is what that's called. I informed Carson that due to the vehicle being on the hydro dam's private property, they requested it be towed. Carson was advised the vehicle would be towed to the Shears lot. So you got in an accident sometime that night, you walked home, you didn't call the police. The dam owner called the police to get your car towed out of there, and then the police called you. that is a misdemeanor offense of leaving the scene of a property damage accident. They didn't cite you for that, but, and now you claim that it's Stellantis's product defect, but you don't have any expert to tell me what it is. Mr. Bentley, what's your position?
Our position is that this is not a defect, that this was either user error or lack of maintenance, where items like brakes are 12-month, 12,000 mile warranty, basic warranty 336, all that has been expired. Owners of the vehicle are responsible for maintenance. So if there was actually an issue with the vehicle, it's not covered under a warranty anymore. But there's been no proof that there was an issue with the vehicle, and the fact that the vehicle was abandoned, and very limited information based on just check, no actual inspection, that this is not an issue that should be represented by Stellantis, and this is an issue with the insurance company or something that or their lack thereof in terms of gap insurance and all that.
You don't have any better expert than she does. You got this crappy assignment from your boss says, hey, show up in court in Centerville and defend this small claims action. The one thing
I
you
do
did
have a
say,
strong background in
yes,
automotive mechanical, so I do know how to
the vehicle was not under warranty. And I don't know how many miles it had on it. I saw something that seemed to say 80.
Your Honor, I did have an extended warranty on the vehicle, but the brakes were deactivated on the vehicle. I put my right hand up. I see that several other people have had the same issue, and it is a shame that Stellantis will not take responsibility. I'm sure there's plenty of other people that have.
Well, there may be a better way to do this with proper counsel and proper expert testimony, but this is a small claims case. And you're unrepresented. You don't have an expert. He doesn't have an expert. And you left the scene of the accident and come back for hours later, which convinces me enough not to grant judgment on your behalf. I don't know whether these brakes were defective or not. I don't think it's brakes. I think it's some sort of computer issue.
It was a computer issue, yes. Yeah.
All right. So it's not under warranty at that point. You have to prove that. All right. Well, if it's under extended warranty, then sue the warranty company. But you're trying to establish in a small claims case with hearsay evidence and an expert who won't come in and testify that this is a defective product, and you haven't met your burden. And you left the scene and didn't come back.
It was nighttime and I did not have my phone on me, and I live right on the same road. I was absolutely freaked out because can you imagine driving a car and all of a sudden your brakes have no control over the vehicle but to steer? In any normal accident, if you look at the pictures you see, if you hit a tree, that vehicle would just stop. This vehicle did not stop.
All right, I can't tell what it is. I can't tell if a brake line leaked all the brake fluid out. I can't tell whether it was a computer chip that went out. I can't tell whether it was operator error. You were driving too fast around that curve. The speed limit there, I believe, is 25 miles an hour. I don't have any estimate of how fast you were going, but your car did go a long way. And so anyway, I find you haven't met your burden of proof. They sent Mr. Bentley out here to represent the company. You can sue him with a lawyer for a product defect, but now you filed this case, which might make it res judicata, meaning you can't bring the case twice. But I find for the defendant, the damages are zero. I find the plaintiff has not established beyond the preponderance of evidence standard that this was a matter of a product defect. Other cases are hearsay. There's no inspection. There's nobody that tells me this is what I inspected and this is what it was. There's some hearsay about maybe it was a computer chip, and you left the scene for hours, 12 hours or more. I don't know what time this happened, if it happened at 8 a.m. or 2 a.m. At any rate.
8 p.m.
All right. Well, there was plenty of time to call the police, and that didn't happen. All right, this case is dismissed. And I find 0 for the defendant, 0 for the plaintiff, and Stellantis not ordered to pay anything. Ms. Carson, are you still at the South River Road address?
I am.
All right, you're all free to go.
Thank you, Your Honor.